And NLS is a community legal clinic established in 1973. Serves a rather large catchment area that spans Yonge Street to the DVP and Bloor Street to the Toronto Islands in the south. And then our areas of law at NLS, we cover immigration, housing, social assistance, and income maintenance, and Andrew does our employment work. From the Don Valley Community Legal Services is Andrew, and the DVCLS is an amalgamated corporation of East Toronto Community Legal Services and Flemington Community Legal Services, both of which have quite long and established histories, and they similarly serve a large catchment area, which spans Victoria Park to Yonge Street, the Don River, and York Mills to Lake Ontario. And in terms of the areas of law that are covered there, they do immigration, housing, social assistance and income maintenance, employment, debt and consumer rights, and also some human rights work. So in terms of finding your closest legal aid clinic, you can access the legal aid website, follow that link, and then input the individual's address or postal code, which should send them the information of the legal aid clinic that serves their catchment area. Legal Aid Ontario also lists several specialty legal clinics on their website, which serve special, certain groups of individuals or deal with specific areas of law. And those can be helpful depending on the circumstances of the case. So moving straight into the immigration material, Asiya and I will cover some of the most important policy changes and updates to the different areas of immigration. As you might imagine, the outbreak of COVID-19 has had an extremely significant impact on immigration, and which has resulted in major disruptions across the board. So we'll start with some general guidance, which is likely to be applicable across a range of application types, before moving on to a discussion of current travel and border closures, which affects migration in general. We'll also talk about the current policies around different categories of applications, including permanent residence, temporary residence, and citizenship, before concluding with some comments about operations at the Immigration and Refugee Board, with this Canada Border Services Agency, and also at the federal court, which are the major administrative and judicial bodies and agencies in the context of immigration. And before we start, I do want to stress that the situation is evolving day by day, with the expectation that things will change as various levels of government and other bodies respond to new information. And so because each case is different, you should ensure that you have the most updated information relevant to your circumstances and to seek legal advice if necessary. Okay. So starting with some general observations. So first, if you've already submitted an application, then it will continue to be processed. There are some exceptions to this. For example, some categories of temporary permits have been put on hold regardless of when they were submitted, but we'll come back to that a little later on. In general, however, pending applications for things like PR or citizenship are continuing to be processed, but you should expect delays in processing times. So second, immigration officers are entitled to request any necessary documentation or to impose regulatory requirements for processing. And this is in relation to all citizenship and immigration applications. This includes requests for things like police certificates, biometrics, passports, and medical examinations. So they're allowed to ask for these things during this time, and you are required to provide them. So, however, that being said, given the widespread disruptions everywhere, IRCC is allowing a bit more flexibility with the timelines for the collection of this information. So when additional documents are newly requested or requested for the first time, the officer will send a request letter, which gives the applicant 90 days to respond. If you're requested biometrics, the letter will say that you only have 30 days, but in reality, it's 90 days as well. If the additional documents were requested before COVID, but the applicant can't meet that deadline for reasons associated with, like COVID closures and delays, the officer should also grant an extension of 90 days. In some cases, IRCC has specified that this extension is automatic, but you should request it to be safe. The best way of submitting a request we found is probably through the IRCC web form, and then you just submit a case-specific inquiry. We're finding that this is often preferable to sending an email, just because a lot of inboxes are full right now and your email will just get bounced back. And finally, some visa application centers or VACs are closed until further notice. So overseas applicants may need to access the services of a VAC, usually for temporary residence applications or to get travel documents for permanent residents or to complete biometrics. You can get information on whether a specific VAC is open or what kind of services are available by following the link to the Find a Visa Application Center page. And then obviously, if a center is closed and the applicant is required to go there for something, then you would want to seek an extension for that. Within Canada, biometric collection services have also been suspended until further notice. In terms of travel restrictions, Canadian citizens, permanent residents, and protected persons are allowed to enter Canada subject to health screening. The travel restriction, which was implemented on March 18th, 2020, applies to foreign nationals and barred most from entering the country for non-essential purposes. So the specific restrictions that apply to foreign nationals varies depending on which country they're traveling from. So a foreign national coming from the United States is only permitted to enter Canada if they have an essential purpose for travel. A foreign national coming from any other country is only permitted to enter Canada, 1, if they have an essential purpose for travel, and 2, fall under one of the enumerated exceptions. So the exemptions include for temporary foreign workers, some international students, some approved permanent residents, and immediate family members of Canadian citizens or permanent residents. If a foreign national falls under one of these categories and they have an essential purpose for their travel, they may be permitted to enter Canada. So to be eligible to travel to Canada, you generally need to have written authorization from IRCC confirming that you are exempt from the travel restrictions. You also need to show a consular or immigration officer that you are coming for some essential purpose. You obviously need to meet all normal immigration requirements and undergo health screening before departure. When you do arrive in Canada, you must have a plan to quarantine for 14 days. This is mandatory, and there are severe penalties for not following this plan. So moving on to different types of applications. So for PR applications, if you submit a new application for PR that's missing documents and you provide no explanation, then the application may be returned. If you submit a new application but explain that missing documents are due to COVID, then the application will be assessed after 90 days. If you have a pending PR application, then as I said before, processing will continue. IRCC has said that no application in progress will be closed or refused due to documents missing as a result of COVID. Again, while they should automatically give you 90 days to complete the necessary steps, it's good to request this extension. And you should also fulfill their requirements as soon as practicable to avoid delays in your processing. If your PR application has been approved, but you have not traveled to Canada, provided that it was approved on or before March 18th, 2020, you're exempted from the travel restrictions and encouraged to use your confirmation of PR or PR visa to land. Again, you must have a plan for a quarantine. On the other hand, if you cannot travel to Canada before the expiry of these documents, then you should use the web form to notify IRCC of the reason. And then as soon as you can travel, you should notify immigration so that they can inform you of next steps. I think at this point, I'm gonna pass it over to Asiya to start speaking about temporary resident applications.
Thanks, Anda. So for new, we're on slide 9, right? Sorry.
Yeah.
I'm not able to see because I'm having technical problems. I apologize. Okay, so for new and pending temporary applications, so similar to the PR applications, applicants can continue to apply for temporary resident visas. These applications can only be done online. And only applicants who meet one of the exemption criteria, which Anna discussed, and who are traveling for a non-discretionary purpose will be processed. This includes both new and pending applications. So the clearest example is probably an individual who's applying to join a close family member in Canada, so a parent, a child, a spouse. Applications submitted prior to the travel restrictions will be put on hold unless the applicant contacts IRCC by email at the designated COVID email that immigration has set up to indicate how they qualify, for one of the exemptions. And supporting documentation must be provided to establish that the exemptions are met. And if immigration is satisfied, then they will issue special authorization to enter Canada. For temporary residents within Canada, so those are people who have work, visitor, or study status, for example, they are required to apply for extensions. Immigration has indicated that there will be no fee waiver for temporary resident application extensions. So included in the online application must be, the fee must be included. For nationals within Canada whose temporary resident status may soon expire should apply for an extension to maintain their status. And this must be done online. It's very important that folks are extending their status because if your status lapses, then you are liable to immigration enforcement. Individuals can apply to restore their status through a restoration application if their status has already lapsed. The fee for restoration is $200, and restoration applications must be filed within 90 days of the lapse of status. So if you find yourself in this situation, it's very important that you reach out to your closest legal aid clinic to get instructions as to how to apply for restoration. Once a foreign national files an extension application, so visitor, student, worker, etc., even if that application is not immediately processed, those individuals will have implied status, meaning that they are able to continue the activities for which they were authorized to enter Canada for. And that status will remain valid until a decision is rendered by immigration. For citizenship applications, our clinic has received a number of queries about delays in processing of citizenship applications. And so immigration has canceled all tests, retests, and ceremonies related to citizenship applications until further notice. New applications for citizenship can certainly be submitted. If documents are missing without an explanation, those applications are liable to be returned as incomplete. If officers are provided with an explanation as to the missing documents and that explanation is related to COVID, then officers are directed to provide applicants with an additional 90 days to provide those documents. Again, if you find yourself in this situation, it's important to keep immigration and citizenship appraised as to the progress that you're making and request any further extensions as necessary. Refugee applications to the IRB. Sorry, I'm just gonna get some water, I apologize.
We don't have fancy bottles of water for our panelists here.
Okay, so refugee applicants and the Immigration and Refugee Board. So individuals who are in Canada are able to make refugee claims by copying their bio page of their passport and other identity documents to the designated email. So these are inland claims. So in Toronto, they typically happen at the Kipling Immigration Office. Recently, immigration lifted the bar for people applying at the port of entry. So now, if you are making a port of entry claim, so you're coming from the US, you're allowed to make a claim. You're allowed to initiate the claim subject to the requirements of the Safe Third Country exemption. So again, it's important to consult a lawyer if you or a family member is planning to make or is making a claim at the port of entry to make sure that the exemptions will apply to you. The board has canceled all hearings. And this is the Immigration and Refugee Board, so it's all appeals, all refugee claims, admissibility hearings. The only hearings that are taking place are detention reviews, so those are people who are on immigration holds. And all the levels of the board have also extended their filing deadlines. These measures are constantly being extended, so no new hearings are being scheduled. The board has indicated that they will give applicants and claimants 30 days notice before their hearing proceeds. So if you have a claim that's scheduled to be heard in 30 days or less, and you haven't received confirmation from the board that your hearing is going forward, you can assume that your hearing is canceled. And you will receive notice from the board as to rescheduling. The board has also indicated that the first hearings to be rescheduled will be the hearings that have been canceled. So those will be held first. Removals and the Canada Border Services Agency. Most removals have been suspended, with the exception of persons who want to leave voluntarily and people with particular admissibility issues. That said, we have been advised that there are some removals that are still happening. So if you find yourself in this position, please contact your legal aid clinic. For individuals who have reporting dates with CBSA, so people who are doing in-person reporting, you can't simply forego the reporting. You need to contact CBSA directly. There's a designated email on this slide. There's also a phone number that you can call, which I'll give you. It's 905-405-3500. So that's the number for CBSA at 6900 Airport Road. And you're to leave a message with your client ID and indicating your reporting date and that obviously you're not able to report due to COVID. Finally, applications at the federal court. All deadlines have been suspended until May 15th, 2020. we believe that this deadline will be further extended. So if you have a federal court matter, make sure to check the federal court website. And the court is also accepting correspondence by fax. And there's a link to the practice directive. So please feel free to check that out or let us know if you have any questions. Thank you. Over to you, Andrew.
Hi, everybody. My name's Andrew Langille, and I'm an employment lawyer with Don Valley Community Legal Services. So, Andrew, do you want to go into the next slide? So what we're going to be talking about today is some common issues that are coming up with COVID-19 in relation to employment law. And I'm going to cover the following areas: layoff and terminations and entitlements upon termination, job protected leaves under the Employment Standards Act. So there's a couple new leaves that specifically relate to COVID-19. Human rights considerations, the CURB, EI, and the Canada Emergency Student Benefit. So these are all income support programs that people can potentially access. And then I'm going to finish with some discussion of occupational health and workers' compensation claims. So just before we begin, I want to just say that this talk is going to focus mostly on provincially regulated workers. There isn't enough time to cover both federal and provincially regulated workers. About 90% of the labor force is provincially regulated in Canada, and there's about 10% that is federally regulated, and those would be telecommunication companies, railroads, airlines, interprovincial trucking, interprovincial shipping. Typically, if you are a federally regulated employee, you will know. But my presentation today is mainly focused on provincially regulated employees, just due to time limitations. Okay, can we go into the next slide? So a lot of people have been laid off as of late. It's an unfortunate fact of the pandemic, with any number of industries and workplaces being deemed non-essential. So there's a question as to whether or not a layoff currently can be treated as a termination, and there's competing laws in play here. Under the Employment Standards Act, it says that you can be laid off for a certain period of time, but under the common law, it says that unless there's a specific term within your contract of employment, you cannot be laid off. And if you are laid off, you are deemed to be terminated. And at that point, you can potentially ask your employer to pay certain entitlements or proceed to the courts to and get the courts to enforce your entitlements for you. So what I would say on the layoff issue is that if you have been laid off and you don't want to return to the workplace, that you need to consult a lawyer sooner rather than later to discuss what options you have. And this is important because the layoffs are very fact-driven scenarios. So what might apply to one person might not apply to another. And the second thing is, it's like most people, that I have talked to as a result of the COVID-19 who have been laid off, most likely want to go back to their job. Asserting that you've been terminated after you've been laid off is probably not the best option for the majority of the people, but for some, it may be an option, and you're going to want to consult with a lawyer on that. So, in terms of if you have been terminated, um, you're going to want to um, seek legal advice before you sign anything. This is very important because if you sign something, then it can limit your rights. And you have two main sets of rights under Ontario law. You have the right to termination and severance pay. Termination pay is typically 1 week per year service up to a maximum of 8. And then severance pay kicks in after 5 years, and you have to be at a larger employer. So it has to have a payroll of over $2.5 million. And that will pay you an additional week up to a maximum of 26 um, per year of service. And then the common law, which comes under any number of names. Probably the best is notice or reasonable notice. So under the common law, you have entitlements potentially that are far in excess of what the Employment Standards Act is going to pay you. And the rights under the common law can range anywhere from 2 to 24 months, depending on how long you've been employed, what your position is, and the availability of alternative employment. So it's important that you do seek rights if you've been terminated. Now, the right to common law notice can be limited by contract via a termination clause. If you do need to seek legal advice, it's important that you email or attend a meeting with a lawyer with your employment contract so that can be reviewed. And there's also other forms of compensation that are available for being terminated, but these mainly relate to breaches of statutes or particularly egregious employer behavior. And those are fairly, I wouldn't say unusual, but in the majority of terminations, they don't really come up that often. But just be advised if you've been treated in a particularly mean or nasty way by an employer, that you may have additional entitlements. Job protected leave. There are 2 new job protected leaves under the Employment Standards Act. The first one is declared emergency leave, and then infectious disease emergency leave, DEL or IDEL. So declared emergency leave, this is what's going to apply to most people. And I would suggest that if you are in this situation, look at the Ministry of Labor's website online. But it's available to anyone due to a declared state of emergency who is unable to work as a result of a government order, a public health order, or the need to provide care or assistance to certain family members. And this includes quite a wide range of familial connections. And I don't actually know if this is a complete list, but go on and look at the Ministry of Labor's website. But typically, if you have to provide care to somebody, you're probably going to be covered. Now, the IDEL is the one that's going to apply to most people. No, DEL is the one that's going to apply to most people. IDEL is more geared to if you actually have contracted COVID-19 or have been ordered to quarantine by a public health authority. So you can see on the screen the different criteria that could fall under it. So it's quite expansive, but it's geared towards people who have typically COVID-19. But this could also apply if you have some sort of disability that puts you at risk of contracting COVID-19, or if you do develop COVID-19, it might increase the severity of the symptoms. You could potentially get put off via a doctor's note by this job protected leave. So you would need to talk to your doctor, and then get a note saying that due to COVID-19 you have to self-isolate or quarantine for a period of time. Now that's a fairly serious decision that I think you have to speak to your health professionals about, and also potentially consult legal advice before you take that step, because it can have certain ramifications in the workplace, but typically you would be covered under the Employment Standards Act, and if you raised a health condition or a disability, you'd be also protected under the Human Rights Code. Some additional points on job protected leaves. Now they can ask for reasonable evidence for DEL or IDEL, but they can't request a medical note. But it may be advantageous in certain circumstances to provide a medical note. Certainly, there was a situation a couple weeks ago that I was involved in where the worker did not want to provide a medical note to the employer, but I thought it was probably the fastest way just to settle the issue. So I instructed them to get a doctor's note just to wrap everything up. So underneath that, there's some discussion about what reasonable evidence is. I would suggest that you document everything in writing, all with the employer, and even if it's verbally, confirm in writing your understanding. You would want to do this because if there's any potential reprisal on the part of the employer for taking a leave in the future, you want to be able to refer back to that documentation if you want to initiate legal proceedings. The protections under the ESA are quite strong for job protected leave. So if you were to get fired for taking a leave, you could potentially be reinstated, or the Ministry of Labor could order arrange remedies, and you'd also have the ability to seek remedies through the courts as well. The leaves are retroactive back to January 25th, 2020. And there's no specified time limit as to how long you can spend on either of the leave. And there's a number of other leaves that I don't think necessarily apply, but it's good to know, and those are listed at the bottom of the screen. Human rights considerations. I'm not going to dwell on this very much because I think we want to get to some questions. But understand that all workers and this would mean employees, contractors, independent contractors, dependent contractors. Everybody is covered under the Human Rights Code in Ontario. And it provides protections against discrimination, harassment, sexual harassment, and reprisals. Now, the protections against discrimination and harassment are only in certain areas. These are called protected grounds. You can just type in Ontario Human Rights Code, and it'll give you a complete list. But some examples are family status, marital status, religion, sexual orientation. And there are a variety of ways that the Human Rights Code can come into play in relation to COVID-19. So one example is COVID-19 is considered a disability under the Human Rights Code, and an employer cannot discriminate against you if you've contracted COVID-19 and need time off, or if you're perceived to have COVID-19. Other examples would be it's like if you were part of a particular ethnic group, you would if somebody engaged in racial harassment in the workplace, you would have a right to complain to the Ontario Human Rights Tribunal about that. That's targeted certain groups, particularly Asian Canadians. Other examples would be family status. If you had to take care of a parent or a child, then you could go to the employer and seek accommodations for that care for the caregiving. So that could include like working from home, flexible hours, and this will be a concern as workplaces and the province are reopened. It's like people may need extended working from home, for example. On the same vein of that, if you have a pre-existing disability or you are immunocompromised, you'd have protections under the Human Rights Code and the ability to request specific working conditions or time off potentially. This would probably most likely have to be done in conjunction with a doctor, but not necessarily. You can enter into discussions with an employer on those points. Can you move to the next slide, please? CURB, EI, and the CESB. So CURB is the Canada Emergency Response Benefit. EI is employment insurance, and the CESB is the Canada Emergency Student Benefit. There's a lot of acronyms. So first off, it's like we're just going to have a brief little discussion about employment insurance. Employment insurance is available to many, but not all workers. Typically, people who are self-employed are not covered under EI, or if you're some sort of contractor or owner-operator, you're probably not covered under employment insurance. So there is an issue around coverage and scope of Canada's employment insurance system. And I should add that it's administered by the federal government via Service Canada. There are a variety of benefits under employment insurance. There's about 7, but the main ones that we're interested in for our discussion are regular and sickness benefits. And I checked this afternoon, and you have to have a certain number of hours to qualify for employment insurance. And this varies from geographical region to geographical region. But in Toronto and the GTA, currently, now the one of the numbers may be dropping, and I'll tell you about that in a second. But for right now, you need to have 600 hours to apply for sickness benefits in the last 72 weeks, and 700 hours for regular benefits. Now, for regular benefits, the number may be dropping down to 665 in the near future, depending on the unemployment rate, or it may stay at 700. So the numbers vary a bit from month to month, but 700 is like a rough guide currently. And what would that entitle you to? So if you qualify for EI sick benefits, you can get a maximum of 15 weeks of benefits. If you qualify for regular benefits, you can get anywhere between 14 to 36 weeks. And this depends on the number of insurable hours that you have in the last 52 weeks. So what that would do is you will, if you qualify, you will get paid up to a maximum of 55% of your income, up to a maximum of $573 per week. But that being said, everybody who's applying for EI right now is getting put onto CURB, and CURB pays out $2,000 per benefit period. And we're going to talk about that next. CURB. Okay, so CURB. Who qualifies for CURB? I've taken the criteria right off the website. It changes sometimes, and they don't tell you, but you have to reside in Canada, and you have to be 15 years of age or older. And you have to have stopped working due to reasons related to COVID-19, or you have to be eligible for EI, regular sickness benefits, or exhausted EI benefits, regular benefits between December 29th, 2019 and October 3rd, 2020. Now, it's a bit unclear because it's like you can still make $1,000 per benefit period. So my understanding is that you can still get the CURB if your hours have been reduced, but you are earning under $1,000 per 4-week period. And then some other criteria. You have to have had $5,000 in income in 2019 or in the 12 months prior to the date of application. Most people will have that, in my experience, and who have not left their job voluntarily. Now, leaving the job voluntarily is, I think, is open to quite a bit of interpretation. And if you were, if there were health and safety issues, if the employer was being unreasonable with regards to your safety, if there was a genuine risk of exposure to COVID-19, then you may be able to still apply, and I don't think there would be an issue. If you do have questions about CURB or eligibility, my best advice is to contact a lawyer. And then just a few points. So when submitting your first claim, you cannot have earned more than $1,000 in employment or self-employment income for 14 more consecutive days within the 4-week benefit period. So this would be the first one. And then when submitting subsequent claims, you can't have more than $1,000 in earnings. So for and then if you're on Ontario Works, on the Ontario Disability Support Program, you can still get you can qualify for CURB if you have all the other eligibility, and you can keep I believe it is $200 plus 50% of the remainder. So that's CURB, and CURB you can apply online. You can apply through Service Canada, or you can apply through the Canada Revenue Agency. And if you have applied for EI after March 15th and you qualify, it automatically rolls into CURB for the first 16 weeks. And then the final slide for the income support is the Canada Emergency Student Benefit, which was announced last week, and it's going to pay $1,250 for May, June, July, and August for qualifying students, and then $1,750 for students with dependents or those with permanent disabilities. And I don't have a lot of other details for you because it was just announced, and nothing has really been formalized as of yet, which is unfortunate. So if you are a post-secondary student, sit tight and wait for further details. And I would simply just check the website every day. So can we go to the last couple slides, Anda, please? Okay. uh, oh, the one before that. Oh, yeah, there we are. So, yeah, health and safety and workers' compensation. This is a bit of a nightmare area currently because it's like Ontario's enforcement of and administration of the Occupational Health and Safety Act and the Workplace Safety and Insurance Act is rather dismal, to be quite blunt. The Occupational Health and Safety Act is administered by the Occupational Health and Safety branch of the Ministry of Labor. And just by way of background, there's been about 4 dozen work refusals that have been filed with the Ministry of Labor in relation to COVID-19, and all of them have been turned down. So the ministry is doing a very poor job of protecting workers, and I say this with like a high degree of reticence that if you do access mechanisms under the Occupational Health and Safety Act, they nothing may come of it, unfortunately. So I think it's critical if you are facing safety issues in the workplace to be proactive, to engage with a lawyer or a paralegal quickly, and then to come up with a strategy to mitigate and minimize the risk that you may face. And this is an unfortunate state of affairs, but this is what the ministry does not seem to want to do its job in the midst of this pandemic, unfortunately. Um, so, with that being said, workers, do have the right to refuse unsafe work without reprisal under the Occupational Health and Safety Act. And this would include refusing to work in an environment where there's an actual safety risk, where one is going to be actually exposed to COVID-19, or may cause one to be exposed to those more vulnerable to severe versions of the virus. Simply a generalized fear of contracting the virus is not enough to amount to an actual safety risk, if the employer has taken adequate steps to reduce COVID-19 risk in the workplace, and the workplace is otherwise safe. So I should also say that some workers who are in essential services may well have to come into work where there's a risk that they will be interacting with the public and therefore have a risk of being exposed to the virus. An actual safety risk in such a scenario includes where the employer is not providing somebody with personal protective equipment, where you're being brought into work despite a confirmed case of COVID-19 in the workplace, or where the employer is not taking active steps to reduce the spread of the virus. Now, all these inquiries are very fact driven. So this is why I keep going back to saying that in a lot of these situations, your best advice is to consult with a lawyer. Can you just go on to the final slide, Anda, please? Oh, there's 2 more slides. So if there is an actual safety risk in the workplace, one has the right to refuse unless you're in one of the designated sectors. So it's like healthcare, policing, detention centers, or another industry listed under the OSHA where dangerous work is a regular part of the job. And those are prescribed under regulation, and that will come up in a quick Google search, but you will probably know already if you are in one of these sectors. So you can engage in a work refusal and file a complaint with the Ministry of Labor. I've told you the current state with COVID-19 and what's happening with work refusals. They're all being refused. Um, uh, So there's, you know, if you have been terminated uh, for um, for raising a health and safety issue in this environment, you can make a complaint directly to the Ontario Labour Relations Board, and it will go to a hearing. What happens is it's a mediation and then an actual hearing. Um, you do have that right, and you know the definition of what a legitimate risk in terms of occupational health and safety may change during the course of the pandemic and as we learn more about how the virus operates. So what I would suggest again is to consult with a lawyer if you're confused about the rights or if you have questions about your rights. And there are specific legal clinics in Toronto that can assist with questions around occupational health and safety. And most of the legal clinics in Eastern Toronto would provide, basic advice on occupational health and safety issues. And then what is my last point? Oh, you can't be fired if you're self-isolating or quarantining due to exposure due to COVID-19, and that would fall under the previous discussion that we had about protected leave. So the final slide, please. So the final slide deals just with workers' compensation. And if you have been exposed to COVID-19 in the workplace and contracted, you can file a claim with the Workplace Safety and Insurance Board, this is the WSIB. They treat cases on a case-by-case basis for COVID-19, which is a bit of a problem. There is no overarching policy that grants coverage to employees when there's been a presumptive contamination or infection by COVID-19. So to start the process of making a WSIB claim, you have to file a Form 6 with the WSIB, and the website is listed here, and they can be contacted at the 1-800 number as well. It's 1-800-387-7050. So just in closing, it's like I realize it was a very stressful time for a lot of workers and people in our areas that we serve. And I would suggest it's like if you do have questions, do not hesitate to contact your local legal clinic because in most cases we will be able to provide advice and assistance. Thank you. And I guess we're going on to questions now. Questions? Maybe we have to take a minute to move on to questions.
Yeah, Jenny, you're on mute there.
Thank you. Hi, I was just talking while muted. So thank you so much, and Asiya and Andrew for your presentations. We're so delighted by the interest in this webinar. There are, I believe, 75 people on Zoom and another almost 30 watching on YouTube Live. So we've got a number of questions that have come in, and they are pretty much divided between immigration and employment question. Of course, many of them are intersecting those two areas. So I think I'll kick it off with an immigration question and try to go back and forth. And of course, and I'm sure you can fill in more details, Andrew and Asiya, but we cannot give legal advice. This is legal information. So I'll try to make the questions as general as possible. Others may share your questions, but we wouldn't be able to give specific advice on someone's specific situation. We'd ask you to call us for a consult. So one question that has to do, asks, for extending temporary status, the deadline right now is October 2020. Is it possible to receive an extension even though in normal circumstances it would be denied. And the example is a postgraduate open work permit that would therefore go beyond 3 years. So being that COVID-19 has affected the ability to obtain work experience hours to apply for the Canadian Experience classes, is there talk of extending these 3-year postgraduate work permits? That's for you, Asiya.
Sure. So what I would say is a person who has a postgrad work permit that's expiring October 2020 has 2 options. The first would be to apply to extend the postgrad work permit, even though, as the individual who asked the question rightly stated, there's no actual extension available of a postgrad work permit, but that person could apply to extend the postgrad work permit and benefit from implied status, and would be able then to continue legally working on an open permit until the application was refused, which it will be, but they would not be engaging in any illegal activity while working on an implied status postgrad work permit. If the person wanted to cease working, but wanted to remain in Canada or had to remain in Canada, then they could also just apply to become a visitor, so that they would have valid status in Canada during that time, but they would not be eligible to work, certainly on just a visitor permit. So hopefully that answers the question.
It sounds like a good area for advocacy as well. Perhaps bring that issue to your local member of parliament. I think fixes are happening all the time, so that there may yet be announcements about that program. So this next question is for you, Andrew. And I know you went into it in your presentation, but it might be good to sort of reiterate what's being asked here is, if the workplace is not safe to go to work, what steps can be taken by employees?
I think I responded to that directly in the chat. That's a tough question to answer if I don't have the specifics. But what I will say generally is this: I would document all safety issues in writing, and like keep an ongoing log of it. I would raise to the degree that you feel comfortable with any health and safety concerns that you have with a supervisor, a manager, or the owner, and then document the response. If you don't get a response from the employer to health and safety concerns, then certainly you can you escalate the matter to the Ministry of Labor. Now, I think that will have differing degrees of success depending on what the health and safety issue is, particularly if it's related to COVID-19. There's also, in larger workplaces or in workplaces where there is a union, typically there is a joint health and safety committee that meets regularly to discuss health and safety issues. Also in larger workplaces, generally they will have a health and safety manager. If all else fails, it's the ministry route would be the way to go. And I would say finally, in particularly egregious situations, I would and I've advised this many times. I've told people just to simply leave the position and seek alternate employment. Because if a workplace has a genuine risk with respect to health and safety, and you feel that you are compromising your physical or psychological safety to go into work, then it's probably not worth it to go in. And you can, if there are health and safety considerations, you can access EI if you quit the job. So those are but a few options that are available. but it varies quite heavily from situation to situation, and depending on the severity and what the specific environment is like.
Okay, thank you. Thank you for that. So back to you, Asiya and Anda. The next question is, are irregular border crossing refugee claimants able to claim inland in Canada?
So yes, if an individual finds themselves in Canada, they are able to initiate an inland claim, subject to whether they have made a claim in one of the 5 I's, which is the ones that are most common for us are Australia and the United States, and whether a credible basis determination has been made in one of those countries. So I would say that the answer overriding is yes, many people will be eligible if they find themselves in Canada to make a claim, subject to their previous claims in any other countries. If they have made a claim in another country that's been determined by a Canadian immigration official to be sufficient enough to bar them from being able to have a claim heard in Canada, they will be eligible for a PRA, a pre-removal risk assessment. It's a very nuanced area of law though, so I would really encourage that individual to seek legal advice before initiating a claim, and most certainly if they've initiated a claim in another country before coming to Canada. Thank you.
Okay, thank you. Okay, Andrew, the next question's for you. It's the question is DEL and IDEL. Maybe you can remind the participants what those acronyms stand for. How do they affect regular sick leave? Do they, and how do they?
I haven't thought a lot about this, but I did answer the question. You can get sick leave a number of ways. There is a number. I believe it's 3 unpaid days under the Employment Standards Act. But then sick days can also be extended via contract. So in an individual contract of employment or under a collective agreement. But the leave, both the declared emergency leave and the infectious disease emergency leave, DEL and IDEL, would be in addition to any sick days that somebody has under the Employment Standards Act. And you wouldn't necessarily have to use up your sick days. I would suspect if you went out under either of the leaves. Certainly for the declared emergency leave, there's no sickness or disability or medical condition component to it. It's more of a generalized leave. For the other one, certainly I could see in some cases an employer asking somebody to take sick days before they went on to the infectious disease emergency leave, but it's going to vary case by case. But I would say they complement each other for the most part.
Thank you. The questions are flying in. So the next is for Asiya. If you're in Canada with a work permit and you're laid off, who's responsible for advising the government?
Sorry, I guess there's a question to the question, and Andrew might actually be able to better answer this. I suppose, I mean, there's no immigration obligation.
Can you repeat the question?
I imagine it matters whether the work permit is open or closed.
Yeah.
Maybe can the person who posed that question clarify, and we'll come back to it.
Is this the question? Who's responsible for advising the government?
Yes.
Yeah.
it's going to depend on what purpose. I would guess. If you're laid off, regardless of whether you're on an open or closed work permit, the employer would have to provide a record of employment under the Employment Insurance Act within 5 days of any interruption of earnings. But that's only going to go to Service Canada. The Citizenship and Immigration, under most circumstances, isn't going to be able to access that record. Neither will the Canada Revenue Agency. So I don't, that would be the only thing that would pop into my mind where there's an obligation to for an employer to notify the government. But for immigration purposes, I can't really answer that. So it's more Asiya's bulwark or Jenny's.
Okay, well, if the person asking the question, anonymous attendee, if you want to clarify, we might be able to get a clearer answer for you, but hopefully that may have covered it.
Or contact us too.
Or exactly, reach out for a consult. I'm going to ask the next question. I'm going to jump ahead to ask you another question, Andrew. How do we know we are exposed to COVID-19 at the workplace in order to apply for WSIB?
That's a tough one. You get sick. It's gonna really depend on the workplace, and it's gonna be very tricky. I would suspect. If you're in a medical setting, if you're in a setting where you're being exposed to a lot of members of the public, I think it would be an easier case to make, but it's gonna depend on like a lot of factors, and the Workplace Safety Insurance Board will go in and do an investigation if there is a claim about exposure in the workplace. But it's gonna depend on what type of workplace it is. Are you interacting with the public? Are you interacting with people who are have COVID-19 or have presumptive cases? So if it's a medical setting, the equation changes quite a bit. But there's a huge number of factors. What I would suggest is, like, if you think you've been exposed, you need to do your utmost to one, isolate, but then two, get tested. But this would only be like if you're actually displaying symptoms, or if you are genuinely concerned that you have been exposed, then I would get tested.
Okay, thank you, Andrew. So Asiya, the next question is for you and/or Anda, and I'll make it a little bit more generic. So people who are here on tourist visas, the tourist visa is going to expire and they can't get a flight back home. A lot of airlines are operating on a very limited basis, if at all. What's the recommended course of action? I think you talked about it in your presentation, but if you could reiterate.
Anda, do you want to answer this one?
Sure, I can give it a shot. So to my knowledge, foreign nationals in Canada whose status is about to expire should apply for an extension to maintain their status. And they are required to do so online, and they have to meet all necessary requirements, including payment of fees. And then as soon as you apply for an extension, and while that's in progress, you have implied status, and then you can remain in Canada until a decision is rendered on your application.
Thank you. Excellent. Andrew, for CERB, CERB, however we choose to pronounce this acronym, for CERB eligibility, has Service Canada announced whether those on EI whose claims run out can then apply for CERB? CURB?
I think I answered that. I'm pretty like if we just let me look at the slides.
Maybe I'll let you, I'll come back.
Oh
There's
no, I have it right now. So what it says is like part of the eligibility is who have stopped working because of reasons related to COVID-19 or are eligible for employment insurance, regular sickness benefits, or have exhausted their employment insurance, regular or fishing benefits between December 29th, 2019 and October 3rd, 2020. But what I would suggest is like if you run out of if your benefits run out and you want to apply for CURB, I would call either Service Canada or the Canada Revenue Agency and speak to an actual agent and get their instructions because it's a bit unclear in my mind. And probably the best thing to do is to contact one of those two agencies to get advice on what to do and then document it. Because if there's an issue later on, you can rely on that record saying that you were instructed to apply and you applied on that basis, and that would potentially overcome any attempts to request somebody to pay back any monies.
excellent, thank you. There are a few questions that have come in that are kind of similar, and maybe we can summarize them and have them answered in one go, Asiya or Anda. And they really have to do with should new permanent residence or citizenship applications be submitted at this time. One question in particular has to do with an in Canada spousal sponsorship application. Should that be submitted now? What's happening to new applications?
Enda? Do you want to answer it?
I can start. Sure. So like new applications to my knowledge are still being processed. If you should, if at all possible, submit the application with all of the required documents. If you are unable to obtain some of the documents as a result of COVID, you should include that explanation in your application, and then they will wait to begin processing it until you've had time to submit that. Incomplete applications without explanation, however, are likely to be returned.
And is there a difference in Canada applications for permanent residence or citizenship versus new applications being initiated from overseas?
I don't know, Asiya, do you want to speak to that?
Sure. I think certainly for in Canada applications, I would encourage folks who have an application that's complete or as near complete as it can be in the circumstances to submit. And the reason for that is immigration has indicated that they are still processing applications. They're just not meeting with individuals. So I think it's a good time to get an application in because officers are still working. So you can sort of benefit from the fact that immigration is not removing anyone or supposed to be really removing anyone, and the fact that officers are presumably in their homes processing these applications. With respect to overseas applications, I think that the difficulty that overseas applicants will face, depending on the type of application they're filing, is the closures of the VACs, the visa application centers. So oftentimes, with various applications, individuals are required to go in and provide biometrics, so retinal scans, fingerprints, digital photos, etc. So I think that is what individuals would want to consider, but it's very VAC dependent. So perhaps if you're in that situation, the overseas situation, maybe consult a lawyer, your clinic, and we can give you some guidance on that. Thank you.
Thank you. Andrew, the next question is for you. And you touched on this in your presentation, people are being laid off work due to COVID. And in some instances, facts might arise where the position has actually been filled by someone else. I'm assuming your answer would be, it would be a good case to reach out to a legal clinic and get a consult. But I wonder if you have any.
I just answer that question, and it sounds like it's like if you've been laid off and your position was given to somebody else, and it sounds like more like a termination than a layoff. So I would consult with a lawyer and get apprised of your rights. That's probably the best course of action. And like I would also apply for CURB or EI if you were eligible to do so immediately.
Thank you. So the next question is for Asiya. Does the government intend on extending IEC visa holders whose experience has been cut short or affected by COVID? This is similar to the question asked earlier.
Yeah, there's a whole website actually right now from immigration that's dedicated to this category of individuals. So I think it's such a highly nuanced area that I would recommend looking at that website first. But sort of high level, immigration, their position now is that they're not going to penalize individuals who are not able to meet the requirements of the program on account if the failure is directly related to COVID. But the website is really helpful. So I would encourage the individual who asked the question to go to the IRCC website and get more information there.
And we have just a few minutes left. Another question for Andrew is there a time limit to apply for the CURB?
I'm just typing out the answer, and this is what I said. Yes, this is a time-limited program. It ends as it currently stands in November or December. I would apply immediately if you're eligible to do so, and you need the money. So yeah, if you want to collect, like if you're eligible to do so and you want to collect the full 16 weeks, and the program ends in November or December, you would have to apply no later than late July, early August to be able to collect the full 16 weeks as it stands.
Asiya and the next question is, are individuals with implied status able to apply for the CURB, especially with so many delayed applications for work permits? How is that being treated?
I think that might be a question more for Andrew. Andrew,
Yep.
do you know the answer?
My understanding is that as long as you have a valid SIN number, you can apply. I don't think implied status will hold you back.
Okay, thank you.
As long as you meet the other eligibility criteria. But I keep going back to that. You would, even if you're on implied status, you still have to meet all the other eligibility criteria.
And I think, Andrew, we've run into this before, right? The difficulty with individuals applying who are on closed versus open work permits, qualifying for EI?
For EI, but CURB is different.
I see.
Yeah.
There was a question earlier about whether these slides can be shared, and the answer is yes. We actually are recording this, so a link to the recording and the slides will be on the website at Neighborhood Legal Services. So do check back. Okay. Another question is for you, Andrew. Someone's been laid off with a closed work visa. What options to maintain status in Canada? Excuse me, I think this actually is for you, Asiya.
Sorry, so they've been laid off. They're on a closed work permit, which is presumably still valid.
Let's presume yes.
Okay, so I think it really depends on what the likelihood is of them returning to Canada, returning to work imminently. I would say that if they believe that they can return to work quickly, that they don't need to do anything because immigration will be forgiving of short-term layoffs. I think that if the individual believes that they're going to face long-term lack of employment, that they should apply for visitor status in Canada to maintain their status.
And probably connect with their legal clinic to get a consult about their specific situation.
Yeah, for sure.
Okay. I think the last question here waiting to be answered then is, and you know, Andrew, I appreciate your typing some individual responses, but I guess for the benefit of those, for all folks who may not be following the chat, maybe we'll make this our last question given the time remaining. The question is that due to flight interruptions, related to COVID-19, travelers are stuck, and there are some who may not be able to come back to Canada to resume their job. People who are actually stuck outside of Canada, are they eligible to apply for the CERB?
As long as somebody is residing in Canada, and that hasn't really been defined. But if you typically live here and have a residence here and have connections to the community and to the labor market, then I would say yes, you would qualify for the CERB. And I've dealt with this exact situation, and my advice to the person who was stuck abroad was to apply, because he had lost his job in Canada when he was unable to return due to the border closures, and he couldn't get a flight out of the country.
Thank you.
Oh, there's one other question.
Yes. So this is for you, Asiya, and apologies, Shahira, if it was overlooked in the questions earlier. The question is regarding PR holders who are stuck abroad. What steps should they be taking? Should they be applying for a one-time travel document to return to Canada?
Sorry, does the question indicate whether or not the person has a valid PR card that's overseas?
PR is coming close to be renewed. So there's a PR card that will be expiring soon.
Okay, so if the person has a valid PR card, they are encouraged to return to Canada immediately, if possible. They will be allowed in if they have a valid PR card, so long as, and they'll be allowed to board a flight so long as they don't appear ill, so long as they don't have COVID or have COVID symptoms. And so long as they have a plan for quarantine, so for the 14 days when they return to Canada. If that individual's PR card expires while they're overseas, then they'll have to apply for a permanent resident travel document. A permanent resident travel document, or a PRTD, will be issued so long as they can establish that they meet the residency obligation. But processing of those permits can be quite lengthy. So I would encourage the person to return to Canada immediately if their PR card is still valid. And Jenny, there's one other question I saw on Skype, on YouTube, which I think probably applies to both Andrew and myself. Did you see that?
I did not. Go ahead and
Okay.
Share it.
Sure. So the question is, how is a person to survive when they make a refugee claim if they don't have any income support? So persons who make refugee claims, and who are determined to be eligible are allowed to make applications for Ontario Works. So if the individual is in Canada, initiates the claim at an in Canada entry through the email, which is listed on the slides, they will likely be asked for additional information from the officer, who will then make an eligibility determination, or sort of a preliminary eligibility determination, and then that individual will be eligible to apply for Ontario Works or ODSP. And perhaps Andrew can answer if that person would also be eligible for any other of the employment programs, though I suspect probably not.
I think with a recent refugee claimant, they probably lack a SIN number, so they probably could not access CURB. And then that would be one of the requirements, that I understand it. And then the question would be, like, do they have income? Because they have to have 5,000 in income in the past 12 months or in 2019. Now that doesn't have to be Canadian income. It can be derived from overseas, from another jurisdiction. But unless you have that, you wouldn't be able to access the CURB. So those are two barriers that would pop into mind. So SIN number is relative. Like you can get a work permit and a SIN number as a refugee claimant, but the income would be the big question in my mind.
Okay, so
sorry to jump in. There's one question floating in the Zoom chat from earlier.
Is this Amaro?
Mm-hmm.
Yes, I do see that one.
Okay.
And I'm conscious that we're a little bit out of time, but I'll beg everybody's patience to ask it to you and Asiya. So people who are applying for permanent residence on humanitarian and compassionate grounds, and their applications in process, they don't have eligibility yet for a work permit or health coverage or social assistance or any of the federal programs. Do you have any thoughts or advice or information, I should say?
Well, folks who have filed an agency application are eligible for OW and ODSP if they qualify. So there are some financial reliefs available to those individuals. So if they're in a position to apply for OW or ODSP, they should do that. Presumably, with the caveat though that obviously the ability to self-support is an important part often of a humanitarian claim. So a short stint on OW or ODSP is often not fatal to a humanitarian application, but might be in the long run. Again, it's very case specific. So happy to chat sort of offline about it.
Thank you. Lots of good questions and lots of fodder to consider reaching out to your local community legal clinics. Most, like neighborhood legal services, do have limited access for walk-ins, but we are all open. We are all working remotely and providing legal services in many different ways, by phone, through various video platforms, and we can see clients in person on an as needed emergency basis. So please do reach out. Stay safe, everyone. Thank you very much for joining us, and we hope that you'll tune in tomorrow as well. We have another webinar. It's listed on the Neighborhood Legal Services website on social assistance and COVID-19. So please do join us tomorrow to hear from two other legal caseworkers on that topic. Thanks so much, Andrew and Asiya.
Thanks to all the participants.
Thank you,
for your
everyone.
time.
Thank you.
Bye-bye. Thank you.
Bye-bye.